One of the most abused areas of the law, in my opinion, is the orders of protection that are available in Illinois. In Illinois, if a person feels they are harassed, stalked, or otherwise abused on a consistent basis by another individual, they can easily obtain an order of protection against them. This is generally the beginning of a larger process where that person is going to accuse you of stalking them, of harassing them in the court of law, perhaps seeking criminal charges against you for those things. Usually, allegations of stalking and harassment are made by somebody that you know, perhaps a paramour, a girlfriend, a boyfriend, other family members, or just friends that have had a falling out of sorts. And the tendency is for people to take these things lightly, but these should be taken very seriously. Oftentimes people feel that the court is about obtaining the truth, and they take no action to protect themselves or defend themselves from these allegations, whether it's in the court for defending an order of protection or whether it's defending harassment charges or stalking charges. The sad fact of the matter is, in a court of law, the truth is what the weight of the evidence says it is. So it's important to prepare a case, to defend a case, whether it's on an order of protection or these specific types of allegations of harassment or stalking or things of that nature, whether it's in person, by driving by someone's house, they say that you're texting them and harassing them, or using other electronic means of communication to harass or stalk them. So it's very important to take the steps necessary to prove that these claims against the accused are false. This includes gathering the necessary evidence and information that can include electronic communications and history, text messages, emails, videos, social media posts, and there are situations where it's a good idea to protect yourself to take screenshots of social media posts, specifically Snapchat, which is engineered to delete itself once it's been viewed. But a screenshot can be admissible in court. The use of screenshots or social media records or phone records or text histories can be used to defend you against these types of allegations. An experienced attorney will know how to go about gathering these records with your help from social media, from text, phone conversations, telephone records, text records kept by cell carriers, and all those things of that nature. These things must be presented to the court to satisfy the legal requirements of foundation. In other words, you can't just walk in with photographs of something or expect that a judge will allow that into evidence in front of a jury or in a trial or any other contested hearing. So if you find yourself accused of wrongdoing either in an order of protection or in a criminal investigation concerning stalking or harassment or actual criminal charges, it's very important to have an experienced defense attorney at your side protecting your interests. These things can get very complicated as far as the evidentiary requirements in court and how an individual goes about defending themselves in a court setting or even during the investigative phase of a case. If the police want to speak to you, it's always important to have counsel. If you are determined to speak to them, have counsel with you or have counsel speak on your behalf, or if your attorney says maybe you shouldn't talk to the police. If you find yourself accused of harassment or stalking or other bad behavior in the allegations contained in an order of protection that's been issued against you, and you want to have a consultation concerning that, you can call the Lonergan Law Group at 309-673-3939.